Hello and welcome to Admitted, an introduction to effectively presenting evidence. This is part one of a two-part presentation. My name is Aaron England, and I am the chair of the Bench and Bar Committee for the Northern District of Georgia Bankruptcy Court. This is the 11th installment of the Lunch and Learn program from the Bench and Bar Committee. As a reminder, all of the prior presentations and this one will be available online at ganb.uscourts.gov/bench and bar committee. That will include all past presentation materials and a video of the presentation. I'd like to make a brief announcement to everyone online. The clerk published on May 2nd a public notice for the new form of notice. If you haven't seen that, please be sure to review that and make any appropriate changes to your practice. If there are any questions during the presentation, you can put them into the Q&A box in the Zoom. The panelists will likely anticipate many of the questions, but if we have time at the end, or if there's a question that's pertinent to what's being discussed at the time, then the panelists can address those. I'd like to give some brief introductions for our panelists. First, it says Cavender. He's a bankruptcy judge here at the Northern District of Georgia. He joined the bench in 2018, and prior to joining the bench, he worked as an attorney at Troutman Sanders, Taylor Bean and Whitaker Mortgage Corporation, McKenna Long and Aldridge, and Hicks, Maloof and Campbell. We also have David Johnson. He's a partner at Hurt and Johnson in Dalton, Georgia. He joined Hurt and Johnson, well, I guess it was the Hurt firm at that time, in 2009. He focuses on consumer bankruptcy, Chapter 12 farm reorganization, small business cases, and foreclosure defense. Bryan is a partner at Parker, Hudson, Rainier, and Dobbs. He has 17 years experience in corporate bankruptcy practice. He advises clients on business bankruptcies, creditor rights, commercial litigation, with a focus on secured creditor representation. Nate Juster is the law clerk to Judge Victoria Calvert in the Northern District of Georgia District Court. Prior to clerking for Judge Calvert, Nate was an attorney with Jones & Walden and Atlanta Legal Aid. He was also previously a clerk for Judge Totenberg at the District Court and Judge Deal at the Bankruptcy Court. So please join me in welcoming our panelists.
Thank you, Aaron. We're going to start where we should start, which is with the Federal Rules of Bankruptcy Procedure. And our first slide is, if we can get our first slide, I guess this is the things we're going to cover. Go back one slide, Aaron. These are the things we hope to cover in this session. When do the rules of evidence apply, mass calendars, judges' procedures, types of evidence regularly seen, evidence on a budget, proffered evidence, judicial notice, evidence without experts, relevance, authenticity, documentary evidence, in-person evidentiary hearings, virtual evidentiary hearings, business records, and the best evidence rule. Obviously, if we can't cover all of these, we do have a second session, which we plan to go into greater detail on certain of these rules. So let's get started with the first slide. So hopefully this is not a surprise to all of you, but the rules of evidence actually apply in bankruptcy cases. Bankruptcy Rule 9007 says the federal rules of evidence apply in cases under the code, and that obviously includes all cases under all chapters. It includes contested matters under Rule 9014, and it certainly includes adversary proceedings and motions for judgment, summary judgment filed in adversary proceedings. Importantly, though, you need to know if you have an issue where you think evidence is going to be needed on a contested matter, you need to know what the rules are for each judge as to how they hear evidentiary matters. All the judges in the Northern District have a specific rule which says that if a matter is going to take more than 20 minutes, it's not appropriately heard on a mass calendar. And so you need to know what your judge's rules are for hearing evidence. Obviously, some things can be done in 20 minutes with evidence. Certainly, proffers of testimony can be taken on a mass calendar. Requests for judicial notice can be taken on a mass calendar. And in some limited circumstances, testimony can be heard in less than 20 minutes, but it's very rare. So make sure you understand what your judge's procedures are for hearing evidence, particularly as it relates to mass calendars. And so for those of you who don't know, each of the judges in the Northern District has their very own web page, which specifies what each judge's rules are. This is an excerpt picture of my web page, and specifically the hearing information page, which provides available hearing dates, specific rules for in-person, virtual, and telephonic appearances. And each of the judges in the Northern District will have their own set of procedures. Some of ours are the same, but some are different. And so you need to be familiar with the judge you're appearing in front of and what their rules are. As an example, if we'll go to the next slide. This is the specific information with respect to the Chapter 13 calendars on my webpage, and it hasn't changed since June 24th of 2021. And highlighted at the very bottom is for Chapter 13 calendars, evidentiary hearings will be in person unless otherwise ordered by the court. So if you have an evidentiary issue in a Chapter 13 case, you should expect that it's going to be an in-person hearing. That's not to say every evidentiary hearing I have on a Chapter 13 matter is in person, but that's my preferred way of taking testimony and hearing evidence is in person. So you should plan accordingly. If you have something that's going to take more than 20 minutes, this is the special set hearings tab from my web page, and my instructions are that you should contact my courtroom deputy if you have something that's going to take more than 20 minutes. And we'll specially set it, and we'll frequently specially set it for the afternoon when it would otherwise be heard on a mass calendar. But every other judge's rules may be different, and we would have it set at a time as quickly as possible, giving the parameters of the issues that are to be heard. How much time is it going to take? How many witnesses are going to be needed? And so that all those issues roll up into when we would set it and when our calendar would permit it to be set. We also have specific rules. I know I have specific rules, and I know other judges have specific rules about how to submit evidence or documentary evidence to chambers in advance of a hearing. This is from the Adversary Proceedings Contested Matters tab on my webpage, and it specifically deals with submission of exhibits. And if we'll go to the next slide, this is just a picture of a portion of my rules for submission of exhibits. It specifically covers how many days in advance exhibits must be submitted. I particularly like exhibits to be submitted electronically. I'm not someone who wants paper copies in advance. I want them to be submitted electronically on the docket. If you look at my submission of exhibit rules, they look remarkably similar to Judge Sigler's submission of exhibit rules, because I shamelessly stole hers and copied them onto my own page. So they look remarkably like Judge Sigler's, and I appreciate her drafting those initially. But you need to be familiar with each judge's rules for submission of exhibits. Some still prefer paper, some don't. So make sure you know what the deadlines are and what the format is for exhibits to be submitted in advance of any hearing you have. And my final slide is just a general overview of the types of evidence regularly seen, whether it's a stay relief motion, objection to claim, confirmation, or an adversary proceeding. We see all types of evidence routinely, and you should think about these various types of evidence when the other speakers are speaking today, because clearly, if you're going to effectively prosecute your client's case, you need to understand how the rules of evidence apply and how they apply to your specific case. And if you have specific evidence that supports your client's case, how you're going to get that admitted into evidence. Obviously, with stay relief motions, we see all kinds of valuation evidence, objections to claims in the consumer docket in particularly. I think we see a lot of tax returns. Think about how tax returns can be admitted into evidence. Business records. We see a lot of business records, and think about for confirmation hearings, we see a lot of requests for judicial notice and testimonial proffers. Make sure you know how to make a proffer, and these are all things we're going to talk about. So these are just the various types. This is not an exclusive list, but make sure when you're prosecuting your case, you know how to get each of the important pieces of evidence that you have for your client into evidence, given the type of hearing you're going to have. I'm going to turn it next over to David.
Good afternoon, and thank you, Judge. And I apologize ahead of time. There's utility work going right out front, and they just started making some noise. Hopefully that doesn't interrupt much. As Aaron said in the intro, I mostly do consumer debtor work. And my section here, which I've captioned evidence on a budget, is aimed towards helping consumer debtor attorneys accomplish a lot when they may have very little to work with, if you find yourself in a contested situation. Years ago, I was lamenting to one of our bankruptcy judges about the difficulty in dealing with evidence with consumer debtor clients. And the judge, who will remain anonymous, said, well, a secret we have in bankruptcy court is we try to not fuss too much about evidence. And I said, well, that's good to hear. And don't worry, your secret's safe with me, Judge Bonifel. But seriously, when your client has limited resources, they can't take time off work, they're disorganized, they don't have records, it can be very difficult. So I'll be going through some good options if you don't have much to work with. First, if we can go to the next slide, or proffers. So what is a proffer? It's simply an offer of proof or evidence to the judge explaining what would be presented by the witness. So essentially, you know, if put on the stand, my client would testify, and so forth. The purpose of it is to determine admissibility, and that'll rest on a preliminary factor question about whether the testimony would end up being trustworthy. And that's done in jury situations to avoid the jury hearing something they shouldn't have, that shouldn't have been admitted. So why do we use it in bankruptcy? Really, I think it's all about efficiency. And many of you have probably seen this done in Chapter 11 confirmation hearings. The debtor's attorney will make a proffer and literally walk through each subsection of 1129 that the debtor or their manager would testify that the plan complies with the code, it's proposed in good faith, and so on. Now, Judge, if I can ask you, do you require that the client or witness be on the call in order for the lawyer to make a proffer, even if there's no objection?
I do.
You do? Okay. So yeah, practice pointer there. Have them ready, have them on the call so they can back you up. The judge is probably going to require that. Next is judicial notice. So that's Rule 201. The judge on their own, but you should probably request it. They can take notice of a fact that's generally known, or it's readily determined by an accurate source. And once judicial notice is taken, then that fact is deemed proved. So examples under the first prong, widespread conditions. This is something we deal with a lot. So of course, the subprime mortgage crisis and Great Recession starting in 2009. Of course, more recently, COVID and the pandemic. You don't have to prove that these things were going on. You just need to ask the court to take notice of it. The second prong, readily identifiable information or verifiable information, court records and court docket, of course, government data, anything from, you know, weather, sunrise, sunset. I don't think sunrise would be important, but weather might be important for a bankruptcy hearing if it impacted the debtor's business or there was some sort of problem. And I think a big one is prime rate, the prime interest rate. Obviously, with cram down situations until you're going to be utilizing that. Judge, are there any other judicial notice things we could be utilizing? Anything come to mind?
None come to mind. You know, we're frequently asked to take judicial notice of things in the schedules. And so I think, you know, we can take judicial notice that the schedules were filed and they were answered in a particular way, but whether we can take judicial notice of the answer is a different question.
Okay. And if we can go to the next slide. Finally, we've got what I'm calling evidence without experts. Again, with consumer cases, the prospect of getting an expert can be a non-starter if funds are limited. So what options are out there for getting evidence in that might otherwise require an expert? The first is lay witness testimony. They can give opinions. This is governed under Rule 701. It needs to be rationally based on their perception and either helpful to understanding their other testimony or to determine a fact. And of course, it can't be require technical expertise, which would be experts under 702. And this isn't on the slide, but there's also Rule 704 that, yes, the testimony can be the ultimate issue to be decided. Where would this come up? Of course, you've got property valuation. So my question here, so is it no problem to not have an appraisal? Well, maybe. It's well settled that the owner of property can testify as to its value, but you need to be careful. Just because they can testify, that doesn't mean it's going to carry a whole lot of weight, especially if the other side has an expert with an appraisal in hand. And my note here at the bottom about Dobbert, your debtor, of course, Dobbert's for vetting expert testimony. But my point is you should vet your client too, or your witness. Consumer debtors can be unpredictable at times with their testimony, so make sure you prepare ahead of time.
I would say on this point that, if your only witness on value is your client who has an ownership interest in the property, they obviously have a bias, which the court is going to think about when it's thinking about that being your only evidence.
Yeah, that's a good point. And one thing that I found helpful that some clients are capable of doing is actually attacking the other side's comparables. I had a client that one of the comparables the mortgage company was using, and we were trying to strip a second mortgage. He recognized that property and he knew that house was a whole lot nicer than his. And he was able to go out there and take pictures, and we used that and had him go visit some of the other comps. And that was actually very helpful in that case. So if we can go to the next slide. All right, so other options, you've got market reports, commercial publications. There is a hearsay exception for these under Rule 803(8) and 17. And for authenticating them, there's a couple options there under Rule 901 for getting them authenticated. And sometimes with tax assessor records, you could argue that those are self-authenticating under Rule 902, and also with tax assessor records, there's a hearsay exception for that as well. So affidavits, like the judge mentioned early on, we've got federal rule, bankruptcy rule 9017 that applies the evidence rules. It also applies civil procedure rule 43C that you can bring in evidence through affidavits on evidence on motions. So, attach that to your motion or your objection if you're going to use an affidavit. Now, back to market reports. At the bottom here, we've got NADA, Bankrate, and Zillow. From what I've gleaned looking at case law out there, NADA, most courts are happy to take that in that it's trustworthy. Similarly with Bankrate, so that could come up with maybe interest rates or mortgage rates that Bankrate is trustworthy. But Zillow, not so much. Some courts say it's a hearsay problem. I actually think there could be some ways around dealing with the hearsay problem. But the more convincing issue is that Zillow is subject to user input. I think you can kind of sign up with them and say, this is my house, and therefore it's subject to manipulation. So generally, Zillow, you could have a big problem if that's what you're relying on. And Judge, I'll put you on the spot again. Do you have any thoughts on Zillow, or when lawyers attach a Zillow report to some sort of motion or objection?
You know, my view on Zillow is it's some evidence of value. It's not determinative. It's not the end all be all, but it does provide some indications of value. That's all I'll say.
Okay. Yeah, and I do use Zillow a lot. It's so easy to use and quick, and it's there. Personally, I think it often seems high, but it is a good tool out there to at least get you started. Well, that was it for me. So I will turn it over to I think Nate is next.
All right, folks. I'm glad y'all are here. As Aaron let you know, I've been kind of living the last year, even though I'm a bankruptcy lawyer at heart, in district court. In fact, we're in the middle of a jury trial. And so evidence has sort of been kind of a day-to-day for me. So I'm really happy for this opportunity. And I wanted to start with relevance here on my section and citing the rule, because I think for a lot of people, relevance is sort of like, I know it when you see it. Like someone will say something and it'll just sit wrong with you and you'll think that's not relevant. And, you know, it's one of the most common objections you see on TV, you know, how's that relevant? So, you know, this rule kind of provides the general rule. This is sort of the rule of evidence. Relevant evidence is admissible unless the rules provide otherwise. So just, you know, remember that just because something is relevant doesn't mean it's going to come in. Specifically, you know, the rules recognize another rule can keep it out. You can go ahead in the next slide. So evidence is relevant if it has any tendency to make a fact more or less probable, and the fact is of consequence. So you should be getting sort of robotically responsive to relevance objections by starting with, judge, they have to prove this, or judge, I have to prove this. That's number one. And number two is, this piece of evidence or this question makes that more or less likely to be true. So, you know, common examples of irrelevant evidence I have, you know, the trustee's good faith, the creditor's good faith. I feel like we hear that a lot. You know, maybe if this were like an equitable subordination, or like we're trying to like designate a ballot or something like that, that's one thing. But typically in a, you know, an ordinary Chapter 13 confirmation, just because the debtors had a rough go of it, you know, doesn't necessarily mean it goes to their good faith, although it can, right? You know, you just have to think it through. You have to think through, I'm going to prove I have to show that my client has good faith. How is this fact going to increase the probability that the court finds good faith? And, you know, another one that really doesn't need much more saying is that in a Chapter 7, you know, stay relief, there's no reorganization. So, you know, the debtor's need for the property doesn't really factor in. And unfortunately, that's, especially in a pro se situation, that's almost always their objection to the motion for relief. And it, you know, sadly, it isn't relevant because it's not of consequence in the action. So like I said earlier, evidence has to be relevant and not excluded by another rule. So I want to talk a little bit about preliminary questions. I think we heard a little bit about that earlier on in the presentation, but a preliminary question is just any question that has to be resolved in order to determine whether evidence is admissible or not. And preliminary questions, other than privilege, the court is not bound by evidence rules. So that's really important to keep that in mind. Particularly in this relevance scenario, sometimes a fact is necessary to be established in order to determine relevancy. So here's the example I have. Let's say it's a fraudulent transfer case, and the debtor, the creditor is trying to show that the debtor knew that there was a collection notice on the way, and that's why the debtor transferred the property. Well, the debtor can debtor's counsel can object and say, Your Honor, we don't even know if the debtor saw this letter. You know, the letter's not relevant because we don't know whether the debtor even saw it. So how can it be relevant to his, you know, actual intent to hinder, delay, or defraud? Well, you know, the creditor's attorney has two choices in that case. Number one, they can say, Judge, we're not bound by the evidence rules in this preliminary question. We can kind of, you know, just logically speaking, it was posted. It should have been delivered by now. There's no reason to think it wouldn't have been delivered. Or if this is more of a consequential issue and, you know, it's not the type of issue that, you know, a judge might be comfortable just sort of assuming, you can ask for it to be conditionally admitted. And this happens a lot more in jury trials. And that says, Judge, if you let it in, I promise I'm going to introduce this evidence later on in the trial. And then, if you don't, the other side can get up at the close of your evidence and say, Judge, this was conditionally admitted. They never came back and introduced that evidence. And so take it back out. So that's an example of conditional relevancy. So relevant evidence is admissible unless its probative value is substantially outweighed by certain other types of aspects that don't get to trustworthiness, truthfulness, etc. So unfair prejudice, jury confusion, waste of time. Now, I don't think jury confusion will come up in the typical adversary proceeding or contested matter. I think our judges are quite capable of getting their heads around the evidence, but I will say that this rule gives you a lot of latitude to say, Judge, this issue is going to potentially be appealed, and if this is in the record, it's going to just create this cumulative, unnecessary evidence that is going to clutter up the appeal. So even in a contested matter that doesn't involve a jury, I think that's confusion of the issues is relevant. Now, you hear a lot about, Judge, this is prejudicial. Well, anything is prejudicial if it is going to make you win or lose, right? So it's not prejudice per se, it's unfair prejudice. That means that it's going to lead to a conclusion being drawn based on something other than the evidence. It just makes my client look bad, or it makes their client look good. And it has to be substantially outweighed. So even if it's equal, right? Even if it's on balance, this is both probative, but also unfairly prejudicial. That's not enough to keep it out because the general rule is relevant evidence is admissible. So some other things to keep in mind when I said, other rules keep things out, even if they're relevant. 404 addresses character evidence. I think this comes up a lot in a 523A2 case where you're trying to show that the debtor defaulted because they never had the intention of paying to begin with. So, it's fraud because the debtor incurred an obligation without any present intent to repay it. And just because the debtor hasn't paid a debt in the past, or even the fact that the debtor, stiffed someone on purpose in the past, you can't introduce that as evidence to show that they, in this particular occasion, didn't intend to pay. Remedial measures sort of comes up more in negligence cases, but every so often it kind of creeps into other areas. That just says if a party tried to fix a problem, that doesn't mean that the party's admitting there was that they were negligent to begin with. Settlement discussions, I think this comes up a lot. We see things getting mediated. I would just caution you to read the rule carefully because it doesn't exclude all settlement discussions. And sometimes the mediation rules that are entered are even actually the orders are broader than this rule. I've had issues where in a collateral proceeding about attorney's fees, they tried to enter mediation evidence. And they said, well, this doesn't go to establishing liability. It goes to show that you could have settled this and you didn't. So just read the rule carefully. Similarly, 409 is kind of in a similar, just because I offered to pay for your bills when I crashed into you in my car doesn't mean it wasn't your fault for driving in front of me, Aaron. Next slide. Okay, so authenticity. Authenticity is really just a question of, is this evidence real or a fake? And we can go ahead to the next slide. It's really a low bar. The district court or trial court, in any case, really just has to make a prima facie case that the evidence is what it purports to be. And authenticity can always be made a fact issue. It can always be an ultimate issue if, if the issue is, hey, the debtor just sort of found this deed that was never recorded. Whether this deed is the real deed or not, or whether it was just sort of made up, that can be an ultimate issue that can be submitted for determination, but that doesn't keep the document out, right? It still can be admitted, even if there's doubts as to its admissibility. Authenticity can be a trial issue. So it's a really low bar. You don't have to prove that it is what you say it is. You have to make a prima facie case. So we can talk about how to do that on the next few slides. So some pieces of evidence are admissible without proving authenticity. The most common, I would say, would be the certified copies. You know, if you go to a court or a government agency and get a certified copy, for example, if you want to do claim preclusion on a dischargeability case and you want to get the judgment order, you know, you get a certified copy, the clerk will actually stamp their seal on it. And that, you know, shows that this is an authentic court record, and that will be admissible without proving authenticity. Also for business records, you know, if you ever serve a subpoena on a business, you can always attach a request for them to certify the custodian that it is authentic and kept in the ordinary course of business, and so on and so forth. And if you have that authenticity affidavit, then that evidence becomes admissible as to authenticity without any further proof. This one will probably come up a lot. Original signed promissory notes are, you know, commercial paper is considered admissible without further proof. You know, whether a copy is admissible is a different rule. And then newspapers, obviously everyone knows what a newspaper looks like, but maybe not for long. You know, an actual original newspaper is considered authentic without further proof. But all that said, even if a document is not self-authenticating, it's really not that difficult to establish authenticity. So Rule 901 has a sort of a non-exclusive list of ideas, so essentially, like here's some ways you can establish authenticity, but this is not the exclusive. So the most common one is, you know, the witness testifies, is this a fair and accurate copy? You know, and then boom, that's all you really need to do. If a witness has seen this document before, if a witness prepared the document, you know, took the photograph, recorded the call, if they're the ones who had some role to play in the creation of the document, all they have to do is testify that, yep, that's it, and it's in. Non-expert testimony about handwriting or voice. So this can come up if it's a signature in dispute. You don't necessarily need to have testimony that it's an expert testimony saying that this signature is the real signature for the purposes of admissibility. Now, for the purposes of establishing a disputed fact, that might be a fact issue that's submitted to the trier of fact. But that doesn't mean that you can't just say, I'm looked at, here's this signature and here's this signature. They look similar enough to me. The court can admit it based on that. And finally, the item itself, the appearance, contents, substance, internal patterns, or other distinctive characteristics of the item. You know, the court can look at these circumstances even if it's not self-authenticating. So, you know, judges in this district are familiar with reviewing billing records. You know, we can look at a billing record. This is a billing record. It has the firm's, you know, you know, title at the top. It's organized like a billing record. That doesn't mean that it's going to come in. You know, it's still potentially hearsay. It's still potentially barred by other rules. But just to prove that the document is what it seems it purports to be, like I said, it's a very low bar, and it doesn't necessarily need forensic evidence or anything like that. So I think that's it for my portion.
I would just add on authenticity that, you know, for example, our pretrial orders require that an objection be made prior to trial as to a document's authenticity, and authenticity issues can usually be worked out through stipulations of the parties. Rather than having to go the cost and expense of getting certified copies. If the party stipulates that it's an authentic copy, then the court's going to let it in. So
Right.
You usually can work through these authentication issues by cooperating with your opposing counsel.
Thank you, Judge. Thank you, Nate. I'll be taking it from here on and picking up on the issue of documentary evidence. Key points with respect to documents, and this is really for either younger lawyers or lawyers who are not typically and frequently practice in contested evidentiary proceedings. One of the key issues is really to think ahead. Think ahead about what witnesses you would need in order to put on testimony to help get a document admitted. Think ahead about how to physically deal with documents in an in-person or a virtual contested evidentiary hearing. You cannot just assume that the other side is going to agree to the use of documents in a proceeding. even though they are the primary documents at issue in the matter. And so the point of this initial presentation, and we'll dig into it deeper in part 2 of this, is just to help litigators more competently and more efficiently deal with documentary evidence when faced with the pressure of a contested evidentiary hearing or trial. So first, looking at this first slide, one thing to keep in mind is that documents and their contents are typically hearsay because the contents are offered for the truth of the matter asserted therein. Documents, of course, are very commonly used in evidentiary hearings, so they're commonly admitted, but a document itself is inadmissible unless they qualify under a hearsay exception. So the key here is you need a proper foundation to be laid by a competent witness, a witness with appropriate knowledge in order to authenticate the document, to establish that the document is what it purports to be. And we've talked about some authentication today. The document must be relevant. And we'll talk a little bit about the business record exception to hearsay. But I can recall as being a younger lawyer, just hearing commercial litigators talk about documents, they talked about it and thought about it from a standpoint of how do I get it in? It's like, it's not what I know, it's how I can get it in. It's not what I know, it's what I can prove, I think, from the old movie. So the keys that we're going to talk about overall for documents are to pass the kind of the 4-pronged test of being authentic, being relevant, and not unduly prejudicial, being subject to a hearsay exception, and then to finally pass the best evidence rule. So here, this slide is when you're thinking about how to get the document in. It's a bullet point script of sorts for dealing with documentary evidence at a trial. And so this would be for purposes of an in-person evidentiary hearing. And you're thinking ahead about the physical copies of these documents and how you're going to present your exhibit and get it admitted. And so just kind of running through the script here. First, you would take the physical documentation, you'd mark the physical exhibit for identification purposes. If you're in trial, you would go hand a copy of this document to opposing counsel. You would ask the court for permission to approach the witness in order to hand that exhibit up to the witness. And then, of course, you're going to provide the court copies of the documents marked as well. And at this point in time, you're going to then go through the process of the foundational elements, where you're going to ask the witness about their personal knowledge of the document. Do you recognize this document? What is this document? How do you know what the document is? There's a whole host of foundational type questions to establish that this witness would be someone that is trustworthy and competent to testify about what this document is and that it is what it purports to be. And then critically, when you've gone through and laid the foundation, you need to move for the document to be admitted into evidence. And from there, if it's admitted, well, then you can start asking questions about the document itself. But you have to be prepared along the way. When faced with an objection, you have to make a proffer of what the evidence is going to show and why it is relevant. So you have to be prepared to tell the court, this document is X, it's going to establish Y, and that's relevant because of Z. And so these are just things you need to be thinking about ahead of time, what type of objections may be raised, even if it's the critical document in the case. If you don't establish these issues and these foundational components, and you're subject to a potential objection from the other side, you can't just depend on allowing this document to come in and be discussed in court. So I'll lay here at one practice pointer, particularly if you have a very document-intensive proceeding. It is nice to have prepared notebooks ahead of time. So you go to court, sometimes you see people with paper all over the place, and you can sort of work through these stacks of documents, and you can walk up there and do all this that I just laid out. Or if you have a notebook with all of the documents in it, you can really hand those notebooks out at the beginning of the proceeding or when you're questioning, so that you can then just turn everyone's attention to, and the witness's attention to, turn to tab 4. And then everyone goes to tab 4, and you go through the exact same process of laying the foundation. We'll turn to the next slide. Just comparing that process, to virtual evidentiary hearings. And you heard Judge Cavender talk through the rules about sharing all these exhibits 7 days ahead of time, and whatever the rules may be. The reality is in virtual hearings, all of these proposed exhibits will have been circulated and uploaded. All the parties in interest will have seen them, as compared to if you're at a trial, nobody really knows what you might bring in a physical documentation to the trial. So therefore, there is just the surprise element goes away. And kind of skipping to the bottom for a second, for the impeachment is an issue here. And so for impeachment purposes, oftentimes, if the other side doesn't know what documents you might bring, well, there's the opportunity to produce a document from your stack of documents that you brought with you, or maybe it's even in the notebook that you prepared, and use that documentation to impeach something, some testimony by the opposing side. But the issue here is that everything has to be uploaded ahead of time. And save for burying it in a list of 1,000 exhibits, the other side is going to have a chance to have seen that. So one possibility, and Your Honor, you can maybe weigh in on this. The possibility is that if there was some particularly important piece of impeachment evidence that one wanted to hold back, is it a possibility to file it under seal?
I certainly would. No one's ever asked me to do it, but I could see in certain circumstances if somebody had some strong impeachment evidence or rebuttal evidence, that I would consider allowing them to be filed in advance under seal, so that they could be used at a virtual hearing.
Go to the next slide, talking about business records. And one of the keys to business records is that they're just generally considered more reliable than a lot of other types of documents. And so the focus here is an exception to the hearsay rule, is to focus on when the documents were created, the trustworthiness of the documents, and whether they were created in the course of regularly conducted business. Because of the reliability of those documents, it can be easier to get admitted. If we'll go to the witness, the next slide, for the witness that you need to be thinking about in terms of getting business records admitted, what you have to do is the movement must lay a foundation for the testimony of a quote unquote custodian or other qualified witness that these 4 bullet points were all met. One, that the document was made at or near the time of the event at issue. The document was made by someone with knowledge or from information sent by a person with knowledge. And the ones that are really heavily focused on are that the document was kept in the course of regularly conducted activity, and that the making of a record was the regular practice of that activity. So you have to have a witness available to testify who is in a position to attest as to the document's authenticity, and then describe the record keeping process to meet those elements. But this witness does not have to have personal knowledge of the contents of the documents themselves, and the witness is not required to have been a custodian at the time that the record was made. They just need knowledge of the procedures under which the records were made and maintained. Keeping in mind, of course, the authenticity, foundational issues must still be established in order to get the business record in. But then as we move to sort of the final piece of the components of getting a documentary evidence and admitted into evidence, after we've established that it's authentic and we've established that it's relevant and established that there's a relevant hearsay exception, perhaps with business records, you do have to consider the best evidence rule. And the best evidence rule itself sort of sounds daunting, and it requires that the original writing, recording, or photograph is required to prove its content, except as otherwise provided. But the rule goes on to provide that a duplicate is admissible to the same extent as the original, unless there's really a genuine question about whether or not the copy is authentic. So in many ways, the best evidence rule is focusing on the issues of fraud and forgeries and altered documents. But also the best evidence rule is to try to prevent witnesses from testifying about their recollection as to what a document said or what it provided, when there's actually a document there that is the preferred evidentiary tool through which to reference what's at issue in the case itself. So as you're dealing with documentary evidence, it's just important to keep in mind that ahead of time who it is you're going to need to bring as a witness, to establish that these documents should be admitted into evidence. And so that's one of the key things that we think that we wanted to touch on, is that so often younger attorneys or those less experienced with trial issues will just sort of, they see the documents are routinely considered and discussed in trial, and therefore if they don't think through ahead of time just the mechanics of how it is you have to deal with the document in order to properly have it considered. So here, the basics of today were to provide you the tools to think about: relevancy, authentication, hearsay exception, and best evidence rule.
The one suggestion, one thing I did as a practicing lawyer, anytime I had a trial or a heavily contested matter that was going to require evidence, is in advance of that trial or hearing, I would reread the rules of evidence. It's a pretty short read. And I would think through the rules in relation to every piece of evidence I have that I was going to seek to offer, and make sure I knew how I was going to get each of those documents in a contested situation. So I would encourage, and something I still do every time I have a trial in front of me, is I reread the rules of evidence in anticipation of having to deal with evidentiary objections that I haven't thought about in a while. It doesn't take very long, and it's just a good refresher on the rules and things you don't think about regularly. So one suggestion. I think we have time for questions if anyone wants to raise a question. I would also suggest, if there are specific evidentiary issues you struggle with or have an issue with that you would like us to cover in the next session, I would encourage you to submit them to the Bench and Bar Committee so that we can focus on them in our next presentation.
And just a reminder that next presentation is coming up on June 12th. It'll be part 2 to this presentation. And we'll have some scenarios to go through, and we'll answer any questions that come up between now and then. It doesn't appear that we have any questions right now, but we can wait a minute and see if any come in. And in the meantime, I'd like to thank all of our panelists and all of our attendees for joining, and hope you all were entertained by the presentation and learned a little something along the way. And stay tuned for part 2. Again, it's on June 12th. And this and all prior Lunch and Learn presentations either are or will be available on www.ganb.uscourts.gov/Bench and Bar Committee. And seeing no questions coming in, I think we can wrap this up.
Thank you all.
All right, thanks.
Thank you.